The chair lays out House Bill 3135 and recognizes its author, Representative Kane, to explain the bill.
Thank you, Chair Collier, Vice Chair Zedler, committee members. Nothing erodes public confidence in our justice system quite like exploitation of loopholes in our laws. When these loopholes are exploited by a child abuser, the situation is more harmful. For example, in a 2018 appellate case, Martini v. State, a 36-year-old man claimed that his abuse of a 16-year-old child was defensible because the child was depressed. In Texas Penal Code, Section 4325, F2 allows for bona fide psychological defense of the harm he caused that child. Despite the current language of the Penal Code, there should be no psychological, psychiatric, legislative, medical, educational, or scientific or other similar justification for inducing a child into a sexual performance or exposing a child to obscene materials. Members, our children deserve to grow up in a Texas free from being induced into sexual performance or being exposed to obscene materials. This long list of exceptions has no place in our code, and these far-fetched defenses will continue to be the refuge of child abusers trying to evade justice. The testimony I believe you'll hear today will explain the origin of these defenses, how they can impact our children, and add context to the need to clean up the Texas Penal Code before more children are harmed. I would say it's important that we recognize that House Bill 3135 only deals with obscenity as defined by the Miller test. That would be a Supreme Court free speech test, guys, based on obscenity, and that House Bill 3135 does not impede or interfere with law enforcement or the prosecution of an alleged crime. And I welcome any questions from the body and ask that I may reserve my right to close.
Chair King?
Can you, I'm looking at the bill, can you explain what the statute as far as the conduct was for a bona fide educational, medical, psychological, psychiatric, judicial, law enforcement, or legislative purpose? So I'm not sure I understand the statute. Tell me again what we're dealing with.
Yes, sir. Well, I think if we were to be creative, we could probably even come up with how they came up with this language to begin with, being legislators ourselves.
So what's the effect of the language as it is? I'm sorry, I just had trouble following you.
Well, one, I think the witnesses will help on that, but
okay,
I can try and
we
give
can do that then. Just wait for the witness.
Okay. Go for it. But these ladies have been dealing with it a little longer, and I think they're more personal than I am. Anybody else?
Speaker Moody?
No questions on the bill. I just want to thank you for sharing with us today on the House floor.
Thank you, Chairman.
I appreciate you.
All right. We'll call you back up to close. Chair calls Jennifer Fleck.
Can I go? Hi. Good evening, Madam Chairwoman and committee members. Thank you for the opportunity to testify. My name is Jennifer Fleck. I'm a parent and an attorney. I am for HB 3135. I have provided the relevant code sections and highlighted the changes that HB 3135 provides. And I also provided sample jury charges that display how these defenses work against children and favor the offender. First, I'd like to address the repeal of the defenses in Texas Penal Code 4324. As we all know, as American citizens, we enjoy the First Amendment right to free speech with few exceptions. Obscenity is one of those exceptions and is not constitutionally protected speech. In order to find a defendant guilty of obscenity to a minor, every juror must agree that the defendant knew for certain that the material was harmful, as defined by the Miller test, and directed it to a child anyway. Although knowing harm should be enough to sustain a guilty verdict, Texas law allows an additional layer of protection for offenders. A defendant found guilty of obscenity to a child may be excused for an education, scientific, governmental, or other similar justification, which is other similar is not defined in the code. If the jury finds that it's more likely than not that there is justification for the harm, then the jury must return a not guilty verdict. Exposing children to legally harmful materials under the guise of education, science, and art appreciation denies Texas children constitutional protection. There are 7 states that do not have these defenses today. Texas should join these states and be leading in the protection of children. Second, I'd like to address the repeal of the defenses in the Texas Penal Code 4325. In 4325, it's an offense to solicit a child for sexual conduct or sexual performance that includes sexual conduct. Again, Texas law provides an additional layer of defense for certain offenders. A defendant found guilty of soliciting a child for sex could assert an educational, medical, psychological, psychiatric, judicial, or legislative purpose. If the jury finds that it's more likely than not that there's a bona fide purpose for the solicitation, then the jury must return a not guilty verdict. The sad truth is that a successful defense as to obscenity or solicitation doesn't mediate or lessen the harm. The child or the family is no less harmed when the guilty are free from consequences and accountability. It's bad law and based on bad science and allows for unsafe environments. These defenses reflect a conscious disregard for the health of children. For these reasons, we ask that you immediately consider taking a vote on HB 3135 and send it to the local and consent calendars.
Madam Chair,
Chair King?
thank you. I'm probably going to regret asking this. Well, first, how long have these defenses been statutory?
Okay, so
this
40
long.
I have the history that I didn't include in your packet, but on 4324, the defenses have been in the code since the Model Penal Code was
So like
adopted.
1975, something like that.
And so the Miller test was, the Supreme Court adopted the Miller test in 1973, and these defenses have been in the code prior to the Miller test, and then these defenses were never taken out of our code.
So I hate to ask this, but can you give me a couple examples where these have been used, these defenses? I'm having trouble envisioning, particularly the legislative.
So I went to the library in the Capitol and tried to research how these defenses originally got in. What I can tell you about 4324 is they were adopted from the Model Penal Code, and that's why a lot of the states have these same defenses.
Can you give me a couple fact situations where they've been used? I'm just
So
curious.
Representative Kane mentioned it, but you may not have caught it. So there was a recent case in Texas, an appellate in Texas. I actually talked to the mother on the phone, and the abuser, one of his defenses was that the pictures, the sexual pictures that he was sending to the child were to cheer her up because she was depressed and suicidal. So I know that sounds ridiculous, and in court you would say, no jury is going to believe that defense. My comment to that is that, however, because the defense is allowed in the code, the family and the child still has to hear the person put on the testimony. So it's lengthening the trial. It's adding confusion to the jury. Now the jury has to consider an affirmative defense, even if it's not credible.
Got it.
It shouldn't be there.
Got it. Yeah,
Just shouldn't be there.
this has been a night for bizarre facts and circumstances.
I have really enjoyed, actually, the committee meeting tonight. Sorry. I'm a weird one, probably. It is late, though.
Does anyone else have any questions for Ms. Fleck? All right, thank you so much.
Thank you.
I'm going to see, is there anyone from the Attorney General? Oh, no, not you, sorry. Office of Attorney General here? Resource? No? Okay, I'm going to call a resource, or somebody that could be neutral, I guess, that's registered neutral. Vincent Giordino, I have a question for you.
Vincent Giardino, Tarrant County Criminal District Attorney's Office, testifying on the bill because I'm still trying to figure it out.
Oh, okay. Well, okay, so then I'm reading this part that removes legislative. So as part of our role, sometimes we get sensitive material, and we get requests from our constituents to ask us, to work through issues for them, and they may send us some sensitive material. Sure. And we know what's in that material. Under the way the statute is written, and I'm so grateful Ms. Fleck gave us the original statute, it says a person commits an offense if, knowing that the material is harmful, he displays harmful material, and knowing the person is a minor, he sells, distributes, exhibits, or possesses for sale, distribution, or exhibition to a minor harmful material. So if we have this material in our possession,
Don't show it to kids.
Well, that too, yeah. So that's what it is, though. So that's what it's saying. Don't show it to other children.
Sure.
Okay.
The only scenario that I can possibly imagine, and I'm grasping here, would be in law enforcement, I believe, is left in, would be showing the child something, saying, can you identify something in the photo? And with that, whenever I've had to show sensitive material to even adults, it is a heavily cropped photo. There's no chance that they're going to see anything other than what I need them to see in order to identify anything. And I've had to do those crops to say, is this you? Is this your daughter? Is this somebody else? And I couldn't imagine showing that to a child, but I'm guessing the law enforcement exception I can see being necessary.
What about judicial? Because it says, would you be under the law enforcement or judicial?
Law enforcement is the exception that I think we're under the judicial branch in the Constitution.
I know, but this bill says judicial.
It does. Now, I don't know.
Not this bill, but the original language in the statute.
The original language allows it for the judiciary. The judge wouldn't be the one that called the kid back. It's going to be an adversarial proceeding with the kid in front of a child advocacy expert, prosecutor, and/or defense attorney. I can't imagine a scenario where a judge would be left alone with a child to show them this material, and the exception would be needed.
Well, I'm
Maybe
just thinking in
not
a judicial
imaginative
setting.
enough. Right, but the judge wouldn't be charged with that. It would be the prosecutor that was showing that. And I don't think anybody imagines that this would be used because of something that happened in a jury trial or a bench trial or any other legal proceeding.
Well, it's removed, so to me it could happen.
In a world of infinite possibilities, maybe, but I don't see. It's really difficult to imagine.
Okay, so you don't think that by removing judicial?
I don't see that as being a problem.
Okay.
I have no heartburn with leaving anything else in, though, because again,
Madam Chair,
failure of imagination on my part.
just to add to it, though, and this is from previous discussions, but the state's attorneys are arranged under the judicial branch
They
of
are.
the state, not the executive branch. It is not the attorney general under the executive branch doing that. So you're judicial officers of the court. So I would think they fall under that. I don't think you're law enforcement. I agree. And so,
That's my concern.
Okay.
So you-
and I could certainly
while
see that
I
as
can't
well.
envision a practical scenario where that would apply, that being that removed, that certainly,
Exposes.
yeah.
That's my only concern.
Then that would be my concern too. But I defer to the wisdom of the committee. Any other questions I can't
Members,
answer?
any other questions? All right, thank you so much.
Thank you.
We might have to call you back up, so don't go far. Chair calls Audrey Werner.
I thank you to the committee. I know it is late, and this is my first time, so it's an honor to be in front of you. My name is Audrey Warner, and I'm a professor who teaches courses on the history of the sexual revolution. I'm also an RN that served at a public health department. I served for 14 years, 5 years as a school nurse, and 9 years as a sexually transmitted disease, HIV, clinic nurse. For 5 years, I taught sex education in the schools and believed what I was told in my training, that I would decrease the teen pregnancy and STD rates. However, when I moved to the STD clinic, I saw the opposite was true. More children were sexually active, and the rape of women and children was exploding. This led me to question why was this happening and who or what was behind it. My research led me to Alfred Kinsey, professor at Indiana University, who was known as the expert on the sexual behavior of the gall wasp. He was considered the father of the sexual revolution, and he did sex studies on humans in the 1930s and 40s. He concluded that children were sexual from birth, incest was not harmful, and one should have sex from birth to adulthood, womb to tomb. How he came to his conclusions is the most alarming. He interviewed pedophiles who raped hundreds of children from the ages of 5 months to 14 years of age. That's on your second page of your packet. There is table 34, documenting one child having to go through 24 hours of sexual contact. How he described a child having an orgasm is they cried, they fainted, and they fought away from the partner. Notice he didn't say perpetrator. Kinsey advocated for the removals of punishment for rape of women and children because as sexual animals, nothing was harmful. He also pushed for obscenity to be shown to children to help them handle their sexuality. The American Law Institute, founded in 1923, used his criminal fraudulent data to draft the Model Penal Code, which was in 1955. Of 197 footnotes of the Model Penal Code, Kinsey is the sole authority on normal human sexual behavior. In the sex offense section. State commissions were set up to look at what's turned old and antiquated laws that once protected women and children. Experts in the field of law and psychiatry and trained in Kinsey's science portrayed children as seducers, which took responsibility away from the adult. Some legal experts advocated for the lowering of the age of consent from 4 to 7 years old. Once laws that protected children from obscenity were removed, there was an explosion of teen pregnancy and STD rates, and those graphs are also in your packet. Bad data has led to devastating results for children. For the past 50 years, we've treated children as sexual from birth, which has led to the public health crisis we have today. The CDC recently reporting that we have the highest STD rates among teens ever. The American Legislative Exchange Council, the largest bipartisan group of state legislators, not only proved that Kinsey's science was fraudulent and criminal, but it has also been used to remove protections for children. Their conclusions, as stated, you also have their state factor is in here. On page 14, it says it's time to review many of the radical changes brought about by the enactment of the Model Penal Code and to restore the safety and security for our most vulnerable citizens, being our children. In current state Texas Penal Code and defenses for those who show obscenity to or have sex with minors was based on a man who believed infants would benefit from having sex with adults, and the data gathered from men who raped children of various ages. There should never be a defense for people who rape children or expose them to obscenity. This bill before you addresses these dangers to children, so I ask you to vote yes on this House bill. Thank you.
Thank you so much. Members, are there any questions for Ms. Warner?
Right.
Thank you for being here.
Thanks.
Chair calls Diana Richards.
Thank you very much for being here this late. It's an honor. My name is Diana Richards of Sherman, Texas, and I'm for House Bill 3135. I'm testifying today on my own behalf as a concerned mother, lifelong Texan, voter, and taxpayer. I've come down from far north Texas at my own cost because I feel strongly that the affirmative defenses in our state's Model Penal Code have been exploited as a loophole, enabling two major issues in the protection of minors that have been discussed tonight. In the matter of harmful materials allowed in the schools and libraries, I was appalled to learn that the book It's Perfectly Normal, which many of y'all have probably seen lately, was found by parents in the state of Texas to be easily accessible to young children. I first heard about the book 7 years ago, and I've done my best to encourage parents to keep their eyes and ears open, because the book's cover seems harmless, but the content inside is offensive when applying contemporary community standards of decency. When the Miller test was laid out, it was also stated it is neither realistic nor constitutionally sound to read the First Amendment as requiring the people of Maine or Mississippi accept public depiction of conduct found tolerable in Las Vegas or New York. Parents in Fort Bend County, where I grew up, found this book in the Fort Bend County Public Library in Richmond, Texas. And in 2017, the library finally moved the book from the children's section. But the cover of this book actually states that it's for ages 10 and up, so anyone could easily make the mistake and put it back in the children's section. We also see the affirmative defenses used by child predators and child sex offenders, as my previous witnesses have talked about tonight. The Martini versus State of Texas case that Mrs. Fleck spoke about was very disturbing to find out that the appellant had sent these messages and intended them, or said he intended them to be emotionally supportive to help her with what he said was severe depression, possibly putting her at risk of suicide. It was used to raise the issue of whether his conduct was for bona fide psychological purpose, protected as affirmative defense. As the mother of a preteen daughter, I urge you to remove the affirmative defenses that have wrongly protected child predators, child sex offenders, and those exposing children to harmful content. HB 3135 would close these exploited loopholes, and I ask you to please consider voting HB 3135 out of committee and hopefully onto the local consent calendar. Thank you so much for your time.
Thank you so much for being here. I know you traveled a long way to be here.
It was worth it.
Yes,
it was totally
ma'am.
worth it.
Members, are any questions? Safe travels back.
Thank you very much.
Thank you.
Chair calls Deborah Simmons.
Hi. My name is Deborah Simmons. I am grateful for this hearing and for the opportunity to testify in favor of House Bill 3135. 5 years ago, I learned that my fifth graders' art class would create imitations of graffiti art. I Googled the artist's name and found cartoon depictions of sexual content, including genital mutilation and bestiality. Concerned, I communicated with the school district and learned about the school district's internet filters. My husband and I improved our home filters, and I encourage other families to do the same. In 2017, I learned about Dr. Alfred Kinsey, the American Law Institute Model Penal Code, and Texas Penal Code Section 43. The art displayed on the Foundation website depicts pictures that meet the definition of obscene and harmful materials for display to minors in Texas Penal Code. I was horrified to figure out that if my child had been exposed to the obscene cartoons through the art lesson, a teacher could have declared an affirmative defense for educational purposes or justification. In Colorado, parents were able to file a lawsuit against the EBSCO online library resource that contained substantial amounts of easily accessible hardcore pornography. Some school districts in Texas have a single login and password for all EBSCO ebooks database collections through TextQuest. A kindergartner and a 12th grader can access the K-8 collection, high school collection, academic collection, etc. When logged into EBSCO, school and home network filters do not filter the content. If a student browses some of the online journals on TextShare, they can click on HTML links that take them to the internet, bypassing the filters on the school and home network. SIPA, the Child Internet Protection Act, was written to require schools to have filters. We teach our children to look away and get an adult when they see something on the internet that makes them feel uncomfortable. The affirmative defenses in Texas Penal Code 4324 and 4325 provide safeguards for predators and abusers. There is a false security as long as those affirmative defenses stay in place. I have censored versions of the bestiality cartoons that I reference. I have uncensored versions of the EBSCO images that children have access to. Originally when we were first looking at this bill, we were just looking at the educational purposes. Why is that there? But this kind of grew because as we looked at the code, this is very concerning. We respectfully ask that you would consider a vote on this and send it to local and consent calendars as soon as possible.
Thank you, Ms. Simmons. Members, are there any questions? Appreciate you being here.
Thank you for your time.
Chair calls Connie Stamps. We're going to show her registered for the bill but not testifying. Is there anyone else wishing to testify on, for, or against House Bill 3135? Seeing none, the chair recognizes Representative Kane to close.
Thank you, members, for your time. I do not envy you that I do not have to. I do get to leave this building after this, and I thank you for y'all's patience, Mr. Moody. And we have heard a lot of interesting things tonight, and I think a lot of these bills can be helping a lot of people. I think you'd be surprised by the bills that I've heard today in this committee, how that light probably won't be red. But with that, I thank you with that, and I do close. If there are any other questions, I do ask for your favorable consideration of this. I think it's time that we go by the Miller standard and protect children from obscenity. I do ask for your favorable consideration.
Representative King, I think that you bring up a very valid issue. I ask that you work on a committee substitute and address this judicial portion, if you would consider that.
Absolutely.
Members, are there any questions for Representative Kane? If there's no objection, House Bill 3135 will be left pending at this time.
Thank you.